In today's video, we're going to be talking about the estate of Philip Seymour Hoffman. My name is Gregory Singleton. I'm an estate planning and probate attorney with Signature Law. Signature Law is an estate planning and probate law firm that serves the Twin Cities and Greater Minnesota alike. Just a reminder, if you like today's video, please feel free to hit that like and subscribe button. It actually really helps support the channel. Also, a couple caveats before we get going. First of all, we're going to be talking about Minnesota law. Well, we're going to be talking about New York law, but with a Minnesota bent on it. Second of all, this video is for educational purposes only. I'm not giving legal advice. And third of all, when we do a look at a celebrity estate, we're not here to gawk at the celebrity's life. This is for educational purposes only and done so with the utmost amount of respect. And today we're talking about the estate of Philip Seymour Hoffman. We know him as an American actor who starred or was featured in such movies as Boogie Nights, Magnolia, Moneyball, Hunger Games, Pirate Radio. He was nominated for the Academy Award for Charlie Wilson's War, Doubt, and The Master, and he won the Academy Award in 2006 for Capote. He had Tony nominations for True West, Long Day's Journey into the Night, and Death of a Salesman. He was truly a spectacular actor. No one can doubt that. However, he was not a very good estate planner. A few things that are relevant about his personal life. First of all, he was not married, but he did have a long-term partner. And with this partner, he had 3 children. At the time of his death, in 2014, February, the children were aged 10, 7, and 5. He was a brilliant actor, but he had a drug problem. When he died in February of 2014, he was 46 years old. At that time, he'd amassed an estate worth $35 million. He did some estate planning. He had a will. It was a short will at 15 pages long. Short will for an estate that size. It was drafted, from what I understand, by his CPA or a real estate attorney and not an estate planning attorney. It was signed and executed October 7th, 2004. Now, there are 3 categories of problems with Mr. Hoffman's estate that I want to focus on. First of all, it's a big estate with a bad plan. Second of all, there was a failure to update this estate and it caused several problems. And third of all, there was a failure to protect the assets and therefore protect his family after he passed. So let's start with the first problem: big estate, bad plan. His estate was worth $35 million. This is pretty hard to ignore. Now, as set up, the estate was a bit problematic for 3 primary reasons, or 3 issues that are brought up with the estate. The first is a lack of tax planning. There was none, to my understanding. Now, the federal estate tax exemption in 2023 is $12.92 million. That means for an estate worth up to $12.92 million, the federal government will not tax any of it. Every penny above that, the federal government will take their share. In 2014, the federal estate tax exemption was only $5.34 million, but still, that's a substantial amount, and you want to do some planning around it. His estate, with being worth $35 million, there's a few things that you can do to plan for taxes. I've seen some people say that he should have gotten married, but let me be the first to say you shouldn't get married just to make your estate planning attorney happy. Get married for the right reasons. It would help, but do it for the right reasons. He could have also done some things with trusts. He could have also given away money to charities. One of his goals was to not have his children be trust fund babies, and perhaps that was a way to deal with it. Because he didn't do any substantial planning, he ended up paying between $12 and $15 million in taxes. Now, he was going to pay something, most likely, but he could have limited his amount of tax liability with proper planning. Now, a lot of people may be thinking, well, I don't have an estate worth $35 million. This doesn't apply to me. But if you think about it, the Minnesota estate tax exemption is only $3 million. And if you have a house, a cabin, a decent retirement account, an investment account, maybe some life insurance, your estate grows to that $3 million mark pretty quickly. I've seen it happen. People get surprised about how much money they have. A great surprise to have. So it's worth, if you're starting to get in the range of having a taxable estate, either on the state level or the federal level, make sure you do appropriate planning. The second issue with having a large estate but not doing any planning is that you're going to go through probate. And this is two problems arise right from it. First of all, probate is expensive. Now, in Minnesota, probate is not prohibitively expensive, but he lived in New York, a state where probate is prohibitively expensive. Personal representative fees and attorney fees can be a percentage of the estate. And when we're talking about a $35 million estate, that's a big chunk of change. That's going to the attorneys and other people and not who you want it to go to. The second issue you have with probate is privacy. If you go through probate, your inventory and your estate become public record. If you have a revocable living trust instead, you get to keep everything quiet, private. But he didn't have a revocable living trust, so everyone's in his business. The second major issue with Mr. Hoffman's estate is that he didn't update it. And for me, this is the important one that really should have been addressed. Basically, Mr. Hoffman should have seen that he was going to have a sizable estate or that his estate was growing quickly. His estate plan was executed October 7th, 2004. He died in February 2014. In 2006, he starred in, or Capote was released, and in 2006, he won the Academy Award, the Screen Actors Guild Award, the BAFTA, and the Golden Globes for his leading role in Capote. At this point, we're pretty sure he's going to be a big thing. I'd even say that in 2004, he was doing well enough that he should have known that his estate was going to be pretty sizable eventually, and he should have done some planning for this. Beyond that, when he executed his estate plan, he had one child. Between the time he executed his estate plan and 10 years down the road, when he passed away, he had 2 more children. They were not accounted for in the will. Now, the law does account for children that are born after the execution of a testamentary document. What they'll say is, you provided for child A in such a way, we're going to do the exact same thing for your other 2 children, or the children that were born after the execution of your estate plan. But that's not something you want to rely upon. You want to make sure that you take care specifically for what they want. And his thoughts may have changed over time about what he wanted to have happen with his estate. Whenever you have a major change in your life, be it having a child, coming across a large amount of money, getting a new job, etc., it's time to update your estate plan. The third problem is he left his estate outright in his will to his girlfriend. Now, we'll get beyond the fact that it was his girlfriend and not his wife, and there's tax issues. That's a matter of whether you get married or not. But what if he left everything to his girlfriend and then they got separated and he didn't want her to have everything? Well, if you were married and you get divorced or your marriage is annulled, at least in Minnesota and every state, I believe, under the Uniform Probate Code, once you get divorced, you're immediately written out of the will as a matter of law. Now, there's some problems with that we've seen in other videos of mine. If you look at previous videos, you can see that the law on that is a little bit shaky, but still there is that protection. If you have a longtime partner but you're not married, first of all, civil unions are not recognized in New York. Second of all, common law marriages are not recognized in New York, or I believe anywhere in the nation. If you get separated, you're not legally separated or anything. You just happen to be whatever it is. There is no legal difference between being together and being separated. So had they separated, he not wanted to leave everything to her, she was still going to get everything because he didn't update his plan. Notably, they did separate. She separated from him because of his drug problem. So that might have been something that needed to be addressed. Second of all, By leaving all the assets to the girlfriend to use to raise the children, there's a few problems. First of all is the lack of ability to control the assets beyond the grave. He could have set up testamentary trusts for each of his children and said, I want the money to be used in this way. And in fact, he had some very specific things that he wanted. A, he didn't want his kids to be trust fund babies, whatever that means. But B, he wanted to make sure that his children were able to, or lived in, or at least visited a couple times a year, such cities, or major metropolitan cities as New York, Chicago, San Francisco. By not setting up his assets in testamentary trusts, he can't control and make sure that that happens. The third problem with leaving everything to your girlfriend or just to your wife and expecting it to trickle down to your children is it may not trickle down. What if he left everything to his girlfriend and then his girlfriend did get married and made a will and they had mirror wills, and the first of her and her new spouse to die leaves everything to the survivor? And in this situation, let's say she dies and leaves everything to her husband, her new husband, not Mr. Hoffman. The new husband possibly could be like, you know what, I don't actually like those 3 kids, or I think they're doing fine. I'm just going to keep the money to myself, and maybe I'll just give all those money to my children from my previous marriage, cutting out Mr. Hoffman's children. Totally legal, seen it happen, terrible thing when it happens. You can prevent this by setting up testamentary trusts and by controlling those assets from beyond the grave in a way that meets your wishes. He didn't do this, and that's a very dangerous thing. The final problem with leaving all the assets to just the girlfriend or even his wife is that it wasn't protected in testamentary trusts. Now, I haven't read the will, by the way. I've looked for it. I wasn't able to find it, but from what I understand, there were not testamentary trusts that were set up. So what if, after his death, she receives whatever is left of the $35 million, let's say it's $20 million after taxes and probate fees. What if she has creditor problems or goes bankrupt? Well, all those assets are accessible by the courts and the creditors. What if she develops a drug problem or a gambling problem? Suddenly, all those assets can go right up her nose or right on the craps table, and there are no protections for the children. What if, again, she gets married and there's a later divorce and some of those assets are taken away from her? None of these protections are in place that could have protected his children. They weren't there. I do hope and I believe everything turned out fine or is working out fine, but you never know. So part of doing your estate plan is protecting your legacy, and that's not what he did. I'm not saying by any means he didn't love his family. I'm saying he didn't do his estate plan. He did what a lot of people don't do, ignore the issue. They don't want to think that at age 46 you're going to pass away, but that's exactly what happened. A lot of money, because of the lack of planning, was lost unnecessarily to probate and taxes. A lot of his assets are out there without protections to make sure his children are taken care of. Mr. Philip Seymour Hoffman was a brilliant actor, but he didn't get the advice of a professional estate planner to prepare his estate, and it led to these problems. Now, I hope it turned out well. I hope his children and his girlfriend are leading productive lives and doing their thing and have used his assets from his estate to improve and better their lives and to raise the children up to the age of majority. But we don't know, or I don't know. I don't tend to look at the families of the celebrities. I feel that that's a little inappropriate. But at the very least, we can learn from Mr. Hoffman's mistake and lack of planning. So that's my take on Philip Seymour Hoffman's estate as part of our Celebrity Estate series. I hope you liked today's video. If you did like today's video, please feel free to smash that like and subscribe button. We do new videos every other Wednesday. If you have any questions, leave them in the comments below or send me an email. Otherwise, until next time, this is Gregory Singleton from Signature Law.